everybody. We are talking about DWI cases again today. It's just been the 4th of July weekend. A lot of people get arrested for DWI. Really every holiday, we end up with a bunch of new cases for DWI. And that is a couple reasons. People do drink more on the holidays, and they get together with friends. They leave their own home and they got to drive back, or somebody's driving back. Some people host the party, right? They're going to be okay. But if you've had any alcohol to drink and you are driving back to your place on a holiday, you are likely to get pulled over. And if you are pulled over on a holiday weekend with alcohol in your breath, you're more likely to get arrested then than any other time of the year. And that is because in Texas, they have what they call no refusal weekends, where they will have officers out on special duty only looking for DWI, pulling people over with the specific mindset of seeing if that person's intoxicated. They run you through a battery of field sobriety tests. There's 3, typically the walk and turn, the one-leg stand, and the horizontal gaze nystagmus. They'll make you do these different tests and then try to determine, is this person not with the normal mental and physical faculties that they should have or that they normally have? And so we always get calls right after a holiday weekend because of this increase in attention. And when there's more attention brought to something, then you're going to have more arrests. It doesn't necessarily mean that you're going to be convicted of a crime. One of the things that we do at my law firm, first, when you call the main number at my firm, you're going to get me on the phone. It's going to come right to this cell phone right here. And wherever I am, I'm going to answer that if I can. If I cannot answer because I'm in court or something like that, then I will forward that number on to an assistant, so that what people are looking for in an attorney, I think, is to get a hold of that attorney quickly so that they get an assessment of their case and get an idea of what they think is going to happen. So what does typically happen in a DWI case? Well, when we're defending a DWI case, we're going to do a few things immediately. We're going to send a letter of representation to the district or county court, and then we're going to send the same letter to the district attorney's office. The district attorney's office is the prosecutors. They're the lawyers that are trying to put you in jail. And so what we do is we will send them a letter, and it will say that we're the attorneys on the case and we need to start getting discovery. Discovery is the process where we request the evidence in the case, and the district attorney has a duty to disclose that evidence to us. 914 of the Texas Code of Criminal Procedure, or the Michael Morton Act, as it was originally passed, I want to say maybe like 2015 or so. Around that time, 2014, I think, around that time, prosecutors' offices around the state were handling discovery either by having a policy where they shared everything in exchange for not filing for certain motions, or they were denying sharing of certain things. For example, I used to be a prosecutor in Brazos County. When I first started back in 2010, there was no open file policy, and we would read what happened to the defense attorney. I can't imagine trying to practice law in that world since I've been a defense attorney. We've had an open file policy mandated across the state through the Michael Morton Act. But when we get those things in a DWI case, we will also request an ALR hearing. And that is a driver's license hearing to help save that person's driver's license from being suspended. One of the most important decisions we make is whether to do this ALR hearing and try to avoid the suspension initially, or to allow the suspension to take place and then get an occupational driver's license through a JP court. One instance will require an interlock if we ever need that occupational later due to a conviction or something else, and the other way will avoid having the interlock device even if we were to take a conviction. So a really common result that we get is, if we cannot get it dismissed, always we're trying to get a dismissal, sometimes the cards aren't there, and a common result we'll get is 3 days, time served, and some kind of a fine. And when we do that, that avoids any kind of probation. It avoids an interlock. If you've got your occupational through a JP court, then you're not going to have an interlock device because of your occupational license. And you just move on with your life. If it's a one-time mistake, something like that, you have the ability to, you end up with a conviction, but essentially no punishment other than the fine. And so that's really helpful for clients who have a very busy, active business. Our business owner clients are really prefer that because, they're not applying for a job later on. They don't really mind a conviction. They just kind of want this thing over with quickly. And we can move quickly sometimes for clients like that. Every case is different. And really, you need to talk to an attorney before you make any decision about what to do with your case. I hope you enjoyed today's educational video, and I hope you like the new office. We've got a nice Southwest reporters back there. We'll see you next time. Thanks for watching, and don't forget to like and subscribe. If you're seeing this on Instagram, make sure to share our reel. Thanks.